Welcome to a new episode of System Update. Tonight, choosing the most overlooked and under-discussed story of 2023 is not a difficult task, at least not for me. Last year, a federal district court judge ruled that the Biden administration committed one of the gravest attacks on the First Amendment's right of free speech in decades, if not in history, by systematically coercing big tech platforms to censor dissent online and to silence various American dissidents the government had singled out. This unconstitutional censorship regime, said the court, was accomplished with many of the key agencies of the United States government, including the FBI, the CIA, the CDC, and the highest levels of the White House itself. Though the case was at a preliminary stage, the court ordered these coercive efforts to cease immediately. The Biden Justice Department then appealed that decision to the Circuit Court of Appeals, which is the level of the federal judiciary immediately below the U.S. Supreme Court. And at the appellate court, a three-judge panel unanimously upheld the findings of that lower court judge in large part. They did narrow the decision somewhat. They found that there was insufficient evidence of the CIA's involvement, for instance. But they did affirm the core finding that the Biden White House, the FBI, the CDC, and other agencies abused its power in a systematic way to coerce and force compliance with its censorship orders by big tech. Now, these decisions were covered by corporate media, but they were radically downplayed. As Elon Musk pointed out over the weekend in response to my statement that I just made here, that I made over the weekend on X, that this court ruling, these series of court rulings were the most undercovered story of 2023, he said the vast majority of Americans have no idea that any of this even happened. And we know why that is. It's because the U.S. corporate media in the United States affirmatively supports the Biden censorship regime that was declared unconstitutional. Indeed, one of the most surreal and destructive facts of American political life is that it is our country's media outlets, which traditionally took the lead in defending values of free speech and a free press, that are now instead the leading agitators and activists for censorship of dissent carried out through the union of state and corporate power, which is what happened here. The U.S. government and big tech uniting to censor dissent. And it is the media outlets that are supposed to defend free speech that have been the leading activists demanding that. Now, to know that is true, one can look at all the different means these media outlets have used to try and exploit their own coercion and their own power to induce big tech to censor, including repeatedly writing stories that they have blood on their hands if they won't censor more. But perhaps nothing revealed this grim reality more, that the media is the leading agitators for censorship. Nothing revealed that more vividly than their reaction last year to the so-called Twitter files. That was when Elon Musk, shortly after purchasing Twitter, opened up the company's corporate files to journalists such as Matt Taibbi and Michael Schellenberger and Lee Fang and others to allow them to show Americans in great detail how aggressively and extensively the Biden administration was engaged in the systematic effort of online suppression. And when that tsunami of censorship evidence was reported and revealed, most of the corporate media united to implore Americans to look away, to ignore the reporting, did everything they could to convince Americans that that reporting did not matter. In behavior that was as revealing as it was creepy, they actually read from the same verbatim script, pronouncing in unison that all of this reporting was a, quote, nothing burger. Now, part of that, to be sure, was standard petty professional jealousy. There is nothing that enrages employees of media corporations more than journalists who break major stories without submitting to the constraints of the corporate masters for whom they work. That, for example, is why they're more than happy to see Julian Assange rotting away in prison, because he has broken more major stories than all of them combined without working within the constraints of corporate media, and they hate him for it. And that was part of the reaction to the Twitter files, but much of it was ideological. These media outlets and their employees favor the censorship regime. In fact, they work to implement it. And so the last thing they wanted was its exposure and its denunciation. And therefore, in the face of one of the most important leaks of corporate documents shedding light, ample light, on this relationship between the state on the one hand and big tech on the other, they actually instructed their flock that it was not even worth paying attention to. These people who call themselves journalists said, ignore these documents, they mean nothing. Now, after the Biden Justice Department again lost at the appellate level an appeal to the U.S. Supreme Court, which decided late last year to hear the case, this morning, the High Court heard oral argument in which a lawyer for the government and a lawyer for the plaintiffs, the people who were censored, presented their arguments. Now, it is often the case, though not always, that it is pretty foolish to try and predict the outcome of a court's ruling based on what they say and do during oral argument. But there was no question that many of the justices on the Supreme Court, if not a majority, were quite sympathetic to several arguments that the Biden administration was making to defend its conduct. In particular, Justice Ketanji Brown Jackson offered one of the most explicitly pro-censorship arguments I've ever heard a Supreme Court justice make. And while her colleagues may not have gone as far as she did, many of them, including some of the conservative justices, seemed quite comfortable, and more comfortable than they should be, with the role the Biden White House has been playing in systematically censoring online dissent. This is one of the most important free speech cases that the Supreme Court has held in years. Far beyond the Twitter files, there has been ample reporting, some of which we have done of ourselves, some of which have been done by others, that prove that it is one of the U.S. government's highest priorities to control and influence the flow of information and opinion online. The boundaries and the limits that they will have to face when doing so, if any, is of great importance. And today's oral argument shed a lot of light on whether they will have any limits at all. And so we will examine that oral argument for you in detail. It's not often that the Supreme Court hears landmark cases that define the free speech rights of Americans. In fact, you can argue that such an event happens maybe once every decade. Oftentimes, you have to go back many decades to understand the scope of free speech rights by going back, for example, to the Brandenburg case that the United States decided in the United States Supreme Court decided in the late 1960s that still defines the outer contours of political speech and what it protects in the United States. Or the Claiborne ruling, which occurred in the early 1980s by a unanimous Supreme Court that sets limits on how people can be held responsible for the consequences of their speech. It's not often that the U.S. Supreme Court issues a landmark ruling that defines free speech. And I would argue that the oral argument that the Supreme Court held today is the single most important free speech case, not only in decades, but the single most important free speech case in the digital era, where it's not newspapers that are our primary means of hearing news, as happened, for example, when the New York Times ruled that the Nixon administration could not issue an order of prior restraint against the New York Times to prevent publication of the Pentagon Papers, another landmark ruling that happened in the early 1970s. It has nothing to do with television. This is about the role that the United States government will be permitted to play in attempting to suppress online political expression, political speech of American citizens on the primary means by which we now trade ideas and hear one another's opinions and news from various outlets, which is the internet. And we have reported extensively on all the different ways that the U.S. government, and not just the U.S. government, but the EU government and the UK government and the Canadian government and the Brazilian government and governments around the world now understand that the power of the internet is so great, is such a threat to power centers and to establishment orthodoxies, precisely because when it's free, it is impossible to centralize ideas and power, and therefore it is impossible to control the flow of information. And that is why Western governments, including the United States, have made it a priority to create theories that allow it to justify why they have to control the internet, why they have to suppress free speech, why they have to censor. And one of the things they do is they have to create theories that justify and convince Americans that they ought to not just tolerate this censorship, but crave it. And one of the arguments the United States government has long made is that we have to keep you safe from hate speech. But a lot of Americans now understand that hate speech is such a malleable concept that it's dangerous to simply endorse the idea that the government can censor hate speech, because that's often in the eye of the beholder. But after 2016, when free speech on the internet led to things like the British people opting to leave the EU through Brexit, and most importantly, the American people defying what they were told to do and voting for Donald Trump instead of Hillary Clinton, it became the number one priority of American financial, political, and media elites to create theories, new theories to persuade Americans to support censorship. And the primary argument they created was that there was this new kind of danger in the internet era called disinformation. Disinformation, we were told, comes often from foreign powers. It helped interfere in the 2016 election and foster the result that American liberals to this day regard as an apocalypse. Disinformation, they say, is what convinced Americans not to take the vaccines they were told to take and therefore died in large numbers. That disinformation is this grave threat, and therefore we need the government to protect us from it. And this has become the leading orthodoxy in liberal thought, including in most parts of the corporate media, which of course have a liberal ideology. These are people who live in liberal cities, who circulate in liberal cultural precincts. And so the idea that the US government has to be able to control the flow of information to protect us from disinformation and the dangers that it creates, including by, even especially by, dictating and influencing and coercing what is and is not permitted to be said online, has become one of the central ideological beliefs of American liberalism, broadly speaking. Meaning everything from the left wing of the Democratic Party to the establishment liberals like Hillary Clinton and Chuck Schumer and Joe Biden and the people who surround him, to the centrist and even parts of the establishment of the Republican Party, who have all united in the belief that disinformation is something that can be defined. Typically, it means dissent from establishment orthodoxies. It is dangerous to be permitted, and therefore we have to censor in order to stop it. And that is what is at the heart of what the Supreme Court had to decide today. And it was obvious that many of the justices on the Supreme Court, not only the liberal justices, but several of the conservative justices as well, believe that it is most definitely an appropriate role for the United States government to play to, at the very least, pick up the phone and call big tech companies in private and convey to them which views they think should be suppressed and which people they think should be silenced. And while most everybody is willing to agree, except for Justice Brown Jackson, that what the US government cannot do is accompany those requests with explicit threats, meaning unless you censor the way we tell you to, we will destroy your company. Pretty much everyone except for Justice Brown Jackson seems to agree that that is not permissive. What they seem to be believing is that even when the US government is throwing its weight around, when they're having the FBI call the big tech platforms at the same time that they're threatening to punish them in all sorts of ways by removing protections under the law that they need, or by attacking them in regulatory and legal ways, that there's somehow nothing sufficiently coercive about that behavior that makes it unconstitutional, even though the 4 federal judges underneath the Supreme Court who have all looked at this question all agreed not only that the Biden administration was violating the Constitution, but was doing so in a flagrant and glaring way. Now, there's other questions that the Supreme Court has to decide that are more technical in nature, which we'll get to, including whether or not these plaintiffs who brought this lawsuit even have the right to sue the US government at all, and whether they could actually prove that the reasons they were censored was because of the US government. But on the merits itself, there were a lot of very disturbing comments that were made, not only by the liberal justices, but by several of the conservative justices as well, including Brett Kavanaugh and Amy Coney Barrett and even John Roberts, that makes me, if I had to bet, believe that it is more likely than not that the US Supreme Court in this case will find a way to reverse the appellate court and the district court and throw this case out and not give the American people what we need more than anything, which is protection from official state censorship through the power of big tech in the digital era. Now, I want to begin by playing for you one of the more encouraging exchanges, which was an exchange that took place between Justice Alito and the lead lawyer for the government, who's the Deputy Solicitor General. And this was Justice Alito explaining to the government what his reaction was when he looked at this broad record of how often and continuously and aggressively the government was telling big tech what they wanted censored.
Exchange between the White House and other federal officials and Facebook in particular, but also some of the other platforms. And I see that the White House and federal officials are repeatedly saying that Facebook and the federal government should be partners. We're on the same team. Officials are demanding answers. I want an answer. I want it right away. When they're unhappy, they curse them out. There are regular meetings. There is constant pestering of Facebook and some of the other platforms, and they want to have regular meetings. And they suggest, they suggest rules that should be applied, and why don't you tell us everything that you're going to do so we can help you and we can look it over. And I thought, wow, I cannot imagine federal officials taking that approach to the print media, our representatives over there. If you did that to them, what do you think the reaction would be? And so I thought, the only reason why this is taking place is because the federal government has got Section 230 and antitrust in its pocket, and it's, to mix my metaphors, and it's got these big clubs available to it. And so it's treating Facebook and these other platforms like they're subordinates.
All right, now this to me goes to the heart of everything. The argument that the government was making to defend the Biden administration, and that several of the justices seemed convinced by, was, look, when the FBI comes knocking on Facebook's door or on Google's door, or the CIA does, or the CDC does, or the Biden White House at the highest level does, and they say, we want this information that you're allowing to be censored. You should not be allowing this information. And then what Justice Alito was saying is they're not polite about it. They're demanding. If they don't get answers right away, they say, how dare you not answer us? We want to hear your answer. They demand meetings. They want regular channels of communication that allow them to constantly submit censorship requests or orders to these big tech companies. Because, as Justice Alito said, the government sees these big tech platforms as their subordinates. And the reason they see them as their subordinates is because, unlike with media outlets, which are protected by the First Amendment, which can publish things even if the government dislikes it, at least this is the old form of journalism. It always used to be that way. The New York Times would publish classified information, and there was nothing the government could do about it. Obviously, during the Snowden report that I did in 2013 for The Guardian and in 2014 and 2015 for The Intercept and media outlets around the world, I was always in conversation with the government, and the government was saying, we don't want you to publish these documents. And if they provided a good reason why we shouldn't, namely if they could convince us that publishing a certain document would cause a lot of harm to innocent people without much value, we would decide, okay, we wouldn't publish that. But that happened very rarely. It did happen one or two times, but very rarely. In the vast majority of the cases, the government understood that the power about deciding whether or not to publish resided with us. And they were trying to convince us politely and through persuasion about what we couldn't publish, but we knew that they had no power to stop us or to punish us if we did. And so the relationship was obviously one of them coming to us, hat in hand, trying to convince us. And what Justice Alito was saying here correctly is that if you look at the way the US government speaks to Facebook and Google and other big tech platforms, it's not that kind of a relationship, because there are all sorts of things that the US government can do to punish big tech if they do not comply. We saw this happen with Parler. Remember, Parler was the free speech alternative to Twitter at the time and to Facebook. And right when President Trump was banished, even though he was the sitting president of the United States, by Twitter and Facebook, something that world leaders, including in France and Germany and throughout Europe that hated Donald Trump, said was extremely alarming, to watch big tech silence the sitting president of the United States, Parler said, we're going to create a platform where there's no censorship, where people can speak freely, just like Rumble is now doing as the free speech alternative to YouTube. And you had government officials, including powerful ones in the Congress, come and tell Google and Facebook, or rather Google and Apple, you better remove Parler from your stores. How can you allow a platform that allows hate speech and disinformation to continue to be downloaded through your stores? And Google and Apple obeyed those requests and took out Parler from their stores, and then Amazon removed it from their web services precisely because they knew that Congress had the power to punish those companies in all sorts of ways. And there have been so many times when Democrats were in control of the House, and now that they're in control of the Senate, where they've summoned big tech CEOs before them, and they've said to them explicitly, we've shown you this so many times, either you start censoring more in the way that we want, you start taking down more disinformation and more hate speech, or we will act against you. So the relationship is inherently coercive. If the FBI calls Facebook, or the White House at the highest level calls Google or Twitter and says, why are you allowing these posts here? Why are you allowing these people here? We want them silenced. The idea that this is just persuasive, that they're just trying to convince these platforms benevolently to remove it, but the power rests with these platforms, is a fifth grade understanding of how the United States government works, especially when it comes to big tech. There are all sorts of protections big tech needs, particularly Section 230, which immunizes them from liability. If a user of Facebook posts something that's defamatory, or if somebody on Twitter posts something that is somehow illegal, Section 230 says these platforms can't be held responsible for what their users publish. If you were to remove Section 230, you would destroy the business model of these companies. And the Biden administration has often held that club, that sword, above their head. Here from Politico in September of 2022, White House renews calls to remove Section 230 liability shield. So they know they have all these weapons in their hands to threaten big tech with. They use it explicitly. Now, the main case that has governed this situation, and it's one that we've covered before, was a 1964 case called Bantam Books. And what happened in Bantam Books is perfectly applicable to what the Biden administration is doing here. And I actually was writing about this before this case even existed. Back in 2019 and 2020, I started saying the US government's efforts to influence what big tech can and cannot allow is crossing over into censorship of the kind that the US Supreme Court in Bantam Books said was unconstitutional, because what happened in Bantam Books was that a bookstore in Rhode Island was selling a book that had sexual themes, and a local zoning board in Rhode Island thought that that book was inappropriate, that it was obscene, that it should not be sold. Now, they knew they couldn't directly pass a law banning the selling of this book, because that would be censorship. That would violate the First Amendment. And so what they did instead was they started threatening the bookstore and the publishing company with all kinds of fines and all kinds of investigations and all kinds of violations. In other words, intimidating them to take down the book voluntarily. And ultimately, the bookstore took down the book, and the publishing company sued and said, yes, the US government didn't directly censor, but what they did was they intimidated the bookstore into doing for the government what the government was barred from doing directly, namely removing the book. That is exactly what the US government has repeatedly done when it comes to Facebook and Google and every other platform, is they're constantly using their threats, both in Congress and in the White House. So when you get a call from the highest level of the White House, and they're not just calling and saying, hey, we would appreciate it if you removed down this post. They call and say, we told you 2 days ago to remove this post. You better effing remove it. And they've used profanity and they use aggression. And they're speaking to them, as Justice Alito said, like subordinates. That is a case where the government has instituted a regime of censorship precisely where the big tech companies know that they don't actually have the option to do it, because if they don't obey, they will be punished. Here is Mark Zuckerberg, the founder and CEO of Facebook, in June of 2023, making an extraordinary confession about exactly what was happening precisely at the time that all of this pressure was being applied. This was during COVID, when the government did not want anybody questioning the efficacy of masks, the efficacy of lockdowns, the efficacy of school closings, and ultimately the safety and the efficacy of vaccines. They were calling Facebook all the time and saying, we demand that you remove this content. This was also a time when the Biden administration did not want anybody questioning the integrity of the 2020 election. And so they would call people up, and they would call Facebook and Google all the time, and they would say, there are these people spreading doubts about the integrity of the 2020 election. Why are you allowing these political viewpoints to remain up? And here is Mark Zuckerberg explaining how Facebook perceived all of that pressure.
So misinformation, I think, has been a really tricky one, because there are things that are kind of obviously false, right, that are maybe factual, but may not be harmful. So it's like, all right, are you going to censor someone for just being wrong? It's, if there's no kind of harm implication of what they're doing, I think there's a bunch of real kind of issues and challenges there. But then I think that there are other places where it is, just take some of the stuff around COVID earlier on in the pandemic, where there were, real health implications, but there hadn't been time to fully vet a bunch of the scientific assumptions. And, unfortunately, I think a lot of the kind of establishment on that, kind of waffled on a bunch of facts and, asked for a bunch of things to be censored that in retrospect ended up being, more debatable or true. And that stuff is really tough, right? And really undermines trust in that. And
so what he's saying there is that you might have people saying factually false things online. Maybe they're saying 2 + 2 = 5. And he's saying, are you supposed to censor them just because they're wrong, even though there's no social harm to them saying that? Maybe they're saying the capital of the state of New York is not Albany, but New York City or Buffalo. Are they supposed to be censored just because they're wrong, because it's disinformation? But what he said was that the government and the medical establishment had declared certain views to be wrong that were not only debatable, as it turns out, but actually that were true. People questioning the efficacy of masks, or the efficacy of or wisdom of school lockdowns or school closures, or the safety and efficacy of vaccines. He was saying the government and the scientific establishment was telling Facebook at the time, you must take this down because it's false. And it turned out, he said, that those things were at least debatable. And some of the things they were demanding be taken down actually turned out to be proven true. Some of the things they were demanding censored. Now, within the investigations that have been done by Congress and within the limited discovery that plaintiffs in this lawsuit obtained, there are all these emails inside Facebook where officials at the highest levels are saying to one another, the government is breathing down our necks and demanding that we remove this content. We don't want to, but we feel like we have no choice. That's something that you can read documents at the highest levels of Facebook where they're saying these are not things we want to take down, but the government is demanding that we do so. And not only does the government have the ability to punish these big tech companies, they also have the ability to bestow on them huge benefits, massive contracts. So if you're the CEO of a publicly traded company like Facebook or Google, you actually have an obligation not to go to war with the US government. Precisely because the US government can harm you in so many ways. You have the duty to maximize the value for your shareholders. And so when the people call who can punish you and destroy your company by removing Section 230, or conduct criminal investigations against you like the FBI can, or who can lavish you with major contracts like the White House and the Pentagon can, when those people call at the highest levels, not junior functionaries, but political leaders at the highest levels call and say, we want these people silenced and we want these posts removed, of course that is not voluntary in any meaningful way. It is inherently coercive. It falls directly into what the Supreme Court in that Bantam Books case said was unconstitutional, namely that once the government starts intimidating private actors or threatening private actors or coercing private actors to engage in the kind of censorship that the government would be barred from engaging in directly themselves, then it becomes unconstitutional. Now, as I said, there were several Supreme Court justices that seemed not just comfortable with the idea that the Biden administration needs to be telling big tech what to take down, but who believe that it's urgent that they do so. And one of those justices was Ketanji Brown Jackson, who made some pro-censorship arguments that were so extreme that it actually kind of shocked me to hear a Supreme Court justice advocating a view of censorship that the Supreme Court has repeatedly rejected. But the reality is, as I said earlier, that it's almost a religious conviction now on the part of American liberals that things like disinformation are so dangerous and social media is so dangerous that, of course, we have to have the government exercising the power to dictate what can and cannot be said. When Matt Taibbi went to testify before the Congress, I remember very well that the House member from Texas, who's a Democrat, whose name is escaping me, he's actually the Democratic nominee to run against Ted Cruz in Texas. We'll get his name. He's a former football player. He now represents Texas in the House. But anyway, in a video I've shown many times, he said to Matt Taibbi, you should be grateful to the people in the CIA. Colin Allred, exactly. His name is Colin Allred. He said, you should be grateful to the CIA and the FBI and the White House for censoring. And if you remove your tinfoil hat, you would understand that these people are acting to protect us from dangerous things online. This is absolutely what is embedded in liberal discourse. That's why every Democrat virtually defends the U.S. security state censorship efforts. It's why the New York Times ran an article this weekend designed to depict free speech as an annoying and dangerous impediment to allowing the government to do what it needs to be doing, which is combating disinformation. And it's why people like Ketanji Brown Jackson, despite having gone to law school and despite being a member of the Supreme Court with decades of precedents that ban censorship, now aggressively defending the need of the government to be able to censor. Listen to what she said.
Well, whether or not the government can do this is something I took up with Mr. Fletcher, depends on the application of our First Amendment jurisprudence, and there may be circumstances in which the government could prohibit certain speech on the internet or otherwise. I mean, do you
hear that? There could be, she said, instances in which the government could prohibit political speech from appearing on the internet. She's not even saying here what some of the other justices seem prepared to say, which is that the Biden administration didn't force big tech to censor anything. They just kind of made nice suggestions, like, oh, we would appreciate it if you removed this post because this contains disinformation. Or this article about vaccines we believe is dangerous. We would like it if you would take that down. That wasn't her argument. Her argument was, even if the government is ordering big tech to censor information, this is something the government has the right to do. I'll just start at the beginning and play that again because it's extraordinary to listen to.
Well, whether or not the government can do this is something I took up with Mr. Fletcher, depends on the application of our First Amendment jurisprudence, and there may be circumstances in which the government could prohibit certain speech on the internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest in how the government has tailored its regulation?
Certainly, Your Honor. I think.
Now, let me just say that sometimes the lawyers that you end up having defend the view that you hope wins don't do a great job at oral argument. And I don't know, Benjamin Aguinaga, he's the Louisiana Solicitor General. This case was originally brought by the states of Louisiana and Missouri by the Attorney Generals. That's why they're the plaintiffs in the case. And this is why the Louisiana Solicitor General ended up arguing the case for the plaintiffs against the Biden administration. He was not an effective advocate at all. He did not come prepared on the core question. Because, of course, there are times when it would be okay for the government to tell big tech, hey, this post contains some really dangerous things. We would appreciate if you would take it down. And the court kept asking, given that, of course, sometimes it's not completely prohibited that the government communicates with big tech, where's the line that you draw between when it is permissible and when it becomes coercive censorship? He was ill-prepared to answer that question, and it really frustrated the justices because I think they were looking for some standard, some line to draw to decide if the Biden administration fell on the wrong side of it. And this question, too, he did not handle well. She was saying that there have to be some instances where the government can, in advance, censor. And instead of saying, no, that's prior restraint, the Supreme Court has often ruled that the government has no power of prior restraint. It cannot censor political speech in advance that way. He agreed with it and kind of mumbled and allowed her to take a very extremist view of censorship and the government's power to do it and to get away with far more than she should have been able to.
Prohibit certain speech on the internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest and how the government has tailored its regulation?
Certainly, Your Honor. I think at the end of every First Amendment analysis, you'll have the strict scrutiny framework in which, in some national security hypos, for example, the government may well be able to demonstrate a compelling interest, may well be able to demonstrate.
All right. So not every situation in which the government engages in conduct that ultimately has some effect on on speech necessarily becomes a First Amendment violation, correct?
Maybe not necessarily, Your Honor. I guess the top line question I would ask is, has the government set out to abridge the freedom of speech? And in this case, you see that time and time again, because if you control
That's not the test for First Amendment violations.
Your Honor, this flows from the plain text of the First Amendment, right?
No, I understand, but we have a test for a determination of whether or not the First Amendment is actually violated. So in certain situations, the government can actually require that speech be suppressed if there's a compelling interest, right?
It can, Your Honor, and I guess what I would say is that the courts below never got to strict scrutiny because the government never raised this. This has never been litigated. The question in this case is whether at the front end the government itself has undertaken
action. Is the coercion, is the state action, right? That's the question in this case.
And I would urge the court to address the state action issue just like you addressed it in Bantam Books. Use that term 4 times in Bantam Books.
And could I just understand, because it seems like an extremely expansive argument, I must say.
So I say that I don't think that's going to be the basis on which the Supreme Court rules in favor of the Biden administration, if it does, namely that, well, sure, the Biden administration censored and they have every right to. But the fact that there was at least one justice on the Supreme Court who now is of the view that the government has the right in advance to censor political speech, what she's referring to is the idea that on some level, every constitutional right can be limited if a very high standard is met. But it's not a prior restraint on free speech. That is never permitted. That was what the Nixon administration tried to do in the case of the Pentagon Papers. When Daniel Ellsberg gave the Pentagon Papers to the New York Times, the Nixon administration tried to stop it in advance from being published, and it went to the Supreme Court, the most important press freedom case in history. And the Supreme Court said, it may be that the government can prosecute the New York Times after the fact for publishing this information if the government can meet all these extremely high standards for being able to prosecute a newspaper, but they can't do it in advance under any circumstances. That would be prior restraint. And what Ketanji Brown Jackson was saying was that, of course, sometimes the government does have the power in advance to say this information on social media is so bad and so wrong and so dangerous that, yes, we have to allow the government to be able to order big tech to remove it. She's defending that position. Here is another exchange where a similar issue emerges, though even in a more extremist and clear way.
Concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. I want to play that again because this is at the heart of it. And this is what the New York Times article from this weekend that I want to review in just a second also tries to implant. She believes, and I think other colleagues of hers on the Supreme Court also are ready to say, that the Supreme Court is like an impediment, or I'm sorry, the free speech guarantee is like an impediment to the government being able to do things it needs to do, that we need it to do. She's saying the First Amendment hamstrings the government from doing things at the most important moments that we need it to do. For example, if there's a COVID pandemic, we cannot allow dissent to the decrees of the scientific establishment about what people should and shouldn't do. It's too dangerous. And we can't allow the free speech right of the Constitution to hamstring the U.S. government from doing the important things it needs to do to protect us. This is exactly what the New York Times did. It depicted free speech concerns as an unreasonable and far-right obstacle to having the government do what it needs to do in this dangerous time, which is protect us from disinformation. This has become the religion of the liberal establishment about why censorship is so necessary, and it became so manifest. I mean, to hear it being advocated by journalists is one thing. To hear it being advocated by a Supreme Court justice is something else entirely. My biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. What would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information.
I mean, I can't let this go in terms of how extremist this is. She created a hypothetical, and several of them did as well. Let's imagine that something really bad is going on online. There's some claim being made that's dangerous or false. And the justices are saying, doesn't the government have to be able to call big tech and say, take this down? And the response of the Louisiana Solicitor General, which in this case was quite good, was no, the government has a lot of options. Joe Biden can go on national television at any moment that he wants. The U.S. government has all kinds of powerful megaphones to counter speech that it claims is false. That's the constitutional framework. The way the government is supposed to respond to speech it regards as false and dangerous is not by calling people up and ordering it to be taken down. That's what the First Amendment is there to prohibit. The solution, if there's dangerous things being said that might be harmful to children or adults in a pandemic, is for the government to go and try and convince Americans that that information is false. And that's what he was saying. The government has solutions. They're not required to sit by silently. Members of the executive branch, members of Congress are permitted, and they do all the time, say, there's things going on online being said that we don't agree with. And then the citizens get to hear from their government. Their citizens get to hear from their opponents and from dissidents of the government. And one of the things social media has liberated us from is the fact that we no longer are imprisoned in the power of a small handful of gigantic corporations, all of whom have the same identical interest in serving the government's messaging. This is what they're afraid of. This is what they're saying. I appreciate Justice Brown Jackson for being as explicit as she is. She's speaking for American liberals here, and she's saying we can't allow free speech anymore. It's too dangerous. That's what's at the heart of this case. It's what is at the heart of the Biden administration's behavior. It's what the heart of all these laws that countries throughout the democratic world are enacting to control the internet, that they believe free speech no longer is a luxury that we can afford. Because not really just hate speech, most importantly, disinformation is something that is too dangerous to permit. And I guess at the end of the day, there probably are two groups of people. One group is a group that believes that the government can be trusted to dictate what is and is not disinformation. And remember, if you think I'm exaggerating, that Homeland Security tried to create an office led by that crazy woman, Nina Yankovic, that was designed to do exactly that. And that became a bridge too far, thankfully, even for our political culture. But the New York Times article this weekend, which I'm about to show you, actually held that up as an example. The failure of the Homeland Security Office as a way in which right-wing fanatics are using free speech to prevent the government from helping us and protecting us. The failure of that Homeland Security Office. So that's one group of people, people who trust the U.S. government to dictate what is and is not disinformation and to censor the internet based on their judgments. And the other group is people who do not trust the government to do that. And I would suggest that the only way to believe in the Constitution is by being in this second group. Now, that's the merits of the case. I do just want to address, because there is a good chance that the court will just absolutely refuse to even get to the merits of whether the Biden administration did here is constitutional or not, because there's a procedural question, which I just want to explain, because it very well may be what ends up deciding the case. And I want to explain what this is, because not a lot of people understand it, and it's extremely important. One of the arguments the government is making is that even if the plaintiffs in this case, which include scientists and journalists and political activists, even if they were censored, they still don't have constitutional standing to sue the government and to obtain a ruling that it was unconstitutional. And the argument that the government is making, that a lot of the judges on this court seem very sympathetic to, was that these plaintiffs cannot prove definitively that the reason their posts were deleted or the reason they were banned from these platforms was because of the government's instructions. So they can prove, the plaintiffs can, that the government told Facebook, we want you to remove anybody questioning the efficacy of the vaccine. But Dr. Jay Bhattacharya, who's one of the plaintiffs who had his scientific assessments of the vaccine deleted, can't prove that he himself was censored because of the government's decrees. Maybe it was Facebook on its own that decided to remove his content. And so in Article 3 of the Constitution that defines the judicial power, the court just can't go around opining in the abstract on whether the government's behavior is constitutional or not. They need to have an actual conflict between two parties. One party has to be able to allege that the other party harmed it. That's the only kind of case that that the judiciary can decide. A case or controversy is how the Constitution defines it. It's a limit on the court. The court can't just go around saying, I think the government acted wrong here. I think this party acted wrong. You need an actual lawsuit between two parties, one of whom harmed the other. And in order to sue the government and obtain a ruling about whether what they did was unconstitutional, before you even get to whether the behavior was unconstitutional, you need to prove that the government acted against you. And a lot of times courts will just dismiss the case without even ruling by saying the plaintiffs don't even have standing to bring this case. This is what was done all the time during the War on Terror. This is something I wrote about more than anything else. Here from Salon in 2009, so 15 years ago. The headline was 180-degree reversal of Obama's state secrets position. What would happen all the time during the War on Terror, first under Bush, and then Obama pretended to oppose it, and then Obama got into office, and the Obama administration did the same thing, which is what this article was about, is that Americans would want to sue the government and say, the government is spying on American citizens without warrants, and that's unconstitutional under the Fourth Amendment. And so often the government would come in and say, the people who brought this lawsuit have no proof that we've actually spied on them specifically. Yes, we are spying without warrants on Americans, but they can't prove that they're on the list of people that we illegally spied on, and therefore they have no standing to even obtain a ruling. And oftentimes the lawyers would ask the court to tell the government, give us the list of the people who they're spying on without warrants so we can bring a lawsuit. And first the Bush Justice Department and then the Obama Justice Department would say, we can't give you that list, it's too secret. And that's what they called it, the state secret privilege. And so often the state secrets privilege was used as a way to keep Americans from knowing who exactly was being spied on without warrants, even though they were admitting they were spying on Americans without warrants. And therefore, so often the court said, no one has standing to challenge whether what the government is doing is illegal. And it very well could be the case that the court will simply refuse to rule on whether what the Biden Justice Department did in calling big tech and pressuring big tech to censor can even be decided at all, because the plaintiffs can't prove that they were censored because of the government. It seems like a technical issue, like an annoying procedural issue. It's actually an important limitation on the court's powers. In this case, there's actually a lot of evidence that the only reason these plaintiffs ended up being censored was because they were expressing the kinds of views that the government was telling these big tech companies they wanted removed. But it's an easy way for the Supreme Court to avoid either having to defend what the Biden Justice Department did here, what the Biden administration did here, or rule against it. And I feel like they don't want to do either. They don't want to justify it, and they also don't want to create a standard that says the government is limited in how it can respond to big tech. And so one way they may get out of it is by using the standing argument to just refuse to rule at all. At the end of the day, it is urgent that we have some kind of standards about what the Supreme Court can and can't do, or what the U.S. government, rather, can and can't do when it comes to convincing and persuading and pressuring and coercing and cajoling big tech companies over whom it has enormous power to censor. And if we don't get a ruling here, we need a ruling soon, because there are few things more dangerous than allowing the U.S. government to be able to continue to dictate what kind of content can and can't be allowed.